Hey there, and thanks for following Cougar Immigration. If you're looking for real talk about Canadian immigration laws, policies, and programs, you are definitely in the right place. I'm Marla Brock. I'm a regulated Canadian immigration consultant, and I'm also an American lawyer for more than 20 years now. I'm going to be your guide through Canada's most complex immigration programs, sharing with you what I know in a way that's easy for you to understand. Today's topic is often relevant to those of you that are already in Canada. If you are already in Canada and you were married or are married still, you were married at the time you came into Canada, but you have yet to divorce your spouse in another country, and you are looking to apply for permanent residency. I often get the question, must I include my spouse on my application, or should I get divorced before I apply for permanent residency? So let me clarify something for all of you. When you are applying for permanent residency, regardless of your marital status, regardless of whether you have children that are the age to be dependent, it is your decision whether you want these relatives to accompany your application for permanent residency. Yes, you heard me correctly. If you are legally married still in your country, your home country, perhaps it's a situation where it's difficult or impossible to obtain a divorce, and you've been living in Canada apart from that spouse, you are estranged, you do not intend to reconcile, you need to understand the importance of legal separation or being separated from your spouse, okay? I would advise that you not delay an application for permanent residency based on your marital status. I do hear of a lot of applicants that are postponing applying for permanent residency until they get divorced. And I wonder, why would they do that when they can simply leave that spouse off of an application, for example, if they do meet the definition of being separated, or they could simply inform Immigration Canada that they are in the process of separating. In any case, it remains a possibility for you to proceed with that permanent residency application, even though you have no intention or desire of bringing that spouse into Canada. There are ways to do this. There are ways to disclose this. And I do not like to see people delaying applications for permanent residency because perhaps obtaining a divorce is not within their financial means at the time. There is a way to get this filed the way that you need it to be filed. Okay? You don't have to include anyone on your permanent residency application that you do not want to. However, you must always truthfully disclose your status. Disclose and explain. Do not delay your permanent residency application because you are deciding to get divorced, or your divorce is pending, or you're separated and you're unable to get a divorce. Do not let that delay an opportunity for you to become a permanent resident. There are a lot of rumors and misinformation out there, and a lot of it is put out by people that stand to make money by having you get divorced first. All right? If you have a question about this, seek professional advice from a licensed immigration consultant. And step 2, call Immigration Canada as well and hear it from them. They will tell you exactly how to make that happen. All right? I know this is timely for many of you. There are permanent residency programs that are open right now in Canada that people are rapidly applying to. So I want to make sure that if you do qualify for permanent residency right now, I would encourage you to explore the option of leaving that other person off of your permanent residency application, but still disclosing that they exist. Okay? I hope that's helpful. Thank you so much for following the page. As always, it's my goal to share with you what I know, and I hope you find it very helpful. Wherever you are in the world, have an excellent day, and I hope to see you in Canada very soon. Goodbye for now.